Good afternoon, ladies and gentlemen. Today is Wednesday, February the 23rd, 2022. It is 3:30 p.m. I'd like to welcome you to the Business and Utilities Subcommittee meeting. I'd like to call it to order. Madam Clerk, please take the roll.
Representatives Alexander, Calfee, Hazelwood, Hodges, Holsclaw, Johnson, Manis, Thompson, Vaughn, Vital, Zachary, Chairman Boyd.
Here.
Mr. Chairman, you have a quorum.
Thank you, Madam Clerk. Members, before we get started today, do we have any personal orders? I would like to welcome the Tennessee Broadband Association. I see a lot of the members out there and hope you guys have enjoyed your day down here on the Hill. If there's no other personal orders, we do have a few administrative items. Item number 1 has been rolled 2 weeks. Item number 8 has been rolled 2 weeks. And item number 4 has been rolled 1 week. All right, let's get started on the calendar. First up is item number 2. That's House Bill 2126 by Speaker Johnson. We have a motion. We have a second. Speaker Johnson, you're recognized on your bill.
Thank you, Mr. Chairman. House Bill 2126 will ensure that the state co-ops will be able to use technology for their members in their meetings. People will be able to fully participate as if they were at the meeting. And we passed a bill last year that allowed nonprofit or for-profit companies to do this. This would simply allow the co-ops.
Thank you, Mr. Speaker, for that explanation. Members, do we have any questions for the sponsor? If not, members, we're voting on House Bill 2126 to send it to full commerce. All in favor say aye. Aye. All opposed say no. The ayes have it. Speaker, your bill is on its way to full commerce. Next up is item number 3, House Bill 2047 by Chair Lady Hazelwood. Motion. We have a motion. We have a second. Chair Lady Hazelwood, you're recognized on your bill.
Thank you. Well, following in the footsteps of our able Deputy Speaker, this is a very similar bill that would allow not-for-profits to have the same latitude as he just described. Again, it's the same thing that we passed legislation last year for for-profit organizations. This would just apply to not-for-profits.
Thank you for that explanation. Members, do we have any questions for the sponsor? If not, we are voting on House Bill 2047 to send it to full commerce. All in favor say aye.
Aye.
All opposed say no. The ayes have it. Chair Lady, your bill is on its way to full commerce.
Thank you.
Next up is item number 5. That's House Bill 2369 by Chairman Powers. We have a motion. We have a second. Chairman, you are recognized on your bill.
Thank you, Mr. Chairman. House Bill 2369 designates the social media platform as a common carrier and requires the entities to obtain a certificate of public insurance and CNN from the Tennessee Public Utility Commission. Today, what I would like to do, Chairman, your request, I would just like to have a couple people here from the Heartland Institute, and we've sent you their names, and we would just like to have them to give some testimony on the bill. I've got a couple of amendments, and I'm going to roll the bill, so I will put the amendments on back when I come back before the committee.
Thank you, Mr. Chairman. So, members, without objection, we will go out of session, and we are going to hear from James Taylor and Carl Sasbo. Are y'all? Oh, 2. Okay, we'll just listen. We'll hear from James Taylor first. And Mr. Taylor, if you will be sure to turn your microphone on and state your name for the record.
My name is James Taylor. I am president of the Heartland Institute. The Heartland Institute is a nonprofit, nonpartisan public policy organization. We believe in freedom-oriented solutions to the problems that confront society. Mr. Chairman and representatives, thank you for the opportunity to be here today. We're here to provide information on the topic of online free speech and big tech censorship. We're neither explicitly for nor against this particular bill, but it is important that certain issues are considered and understood. First of all, I'd like to applaud this committee for considering this bill. Around the country, constituents, well, around the state in Tennessee, but also around the country, people are being censored, and they're very upset about the fact that here we have the online version, the modern version of the public town square, and people are not given access to it. In fact, they're being blocked from it. Right now, we have 3 corporations that between the 3 of them control 97% of social media traffic, and yet they work together to block particular points of view that they object to. It would be one thing if there were many opportunities, many platforms for people to share their views, but there aren't. And this is something that threatens the very nature of our democracy. We are told that we cannot question the Centers for Disease Control and their ever-shifting statements about COVID and COVID-related issues. We are not allowed to question, well, I guess now we are, but before we weren't allowed to question whether COVID originated in a Chinese lab or whether it was natural, and all sorts of other topics, political, cultural, scientific, religious. This is something that needs to be addressed by state legislatures because without free speech, there is no democracy. Sometimes it's questioned, well, is this something that's appropriate for state legislatures? Is it appropriate for lawmakers to get involved? It absolutely is, and I invite you to go back to first principles. In the Declaration of Independence, Thomas Jefferson wrote and our founding fathers approved, it is stated in the very second paragraph, we hold these truths to be self-evident, that all men are created equal and are endowed by their Creator with certain unalienable rights. Among them are life, liberty, and the pursuit of happiness. That to secure these rights, governments are instituted among men. I believe in limited government. I don't believe in anarchy. Thomas Jefferson put it plainly, that governments exist to secure our pre-existing unalienable rights, and free speech is certainly one of them. In this case, we have, again, 3 corporations that control 97% of social media traffic. They're working together to deprive Americans of their basic free speech rights. This isn't a First Amendment issue. The First Amendment is a small subcategory of our larger universe of unalienable rights. We have free speech rights not because government gave them to us, but because they exist as a part of our natural human condition. In this case, we have legislation that would protect those rights, and it is definitely beneficial to the people of Tennessee that action is taken to preserve these rights against the threats that currently exist from big tech censorship. Again, our founding fathers said that the threats to our unalienable rights precede the existence of government, and the reason why we have a limited government at all is to protect these unalienable rights. So thank you on behalf of Tennesseans and people around the country for considering such legislation.
Thank you, Mr. Taylor, for coming and talking with us today. Members, we are out of session. Does anybody have any questions for Mr. Taylor? Representative Thompson, do you recognize?
Is the other speaker about to?
Did you need to speak as well?
Yes, Chairman and members of the committee. I think Representative Powers, we were going to work in tandem.
Yeah, absolutely. State your name for the record.
Absolutely.
And go ahead.
My name is Samantha Fillmore. I'm with the Heartland Institute as well. Thank y'all for holding this hearing today, Chairman and members of the committee. I won't belabor you with points that my colleague just told you. However, I want to go into some specifics about this legislation. We've seen in 2021, we saw 77 pieces of legislation in 33 states attempt to challenge big tech and censorship in some way. Granted, they manifest in a myriad of different ways based on states and the composition of their legislature. And this common carriage bill is a new approach. So if any of y'all might recall or remember, there was a anti-big tech censorship law passed in Texas and in Florida last year. They both were, as we know, struck down in the appellate courts. However, I would like to draw attention to the fact, as I'm sure it will be brought up by others to speak later, that they were struck down in court. It is not the same legislation that is before you today. This common carriage bill is very thoughtful. And furthermore, Texas is in the circuit court 5 and Florida is in 11 and y'all are in 6. So I believe that Tennessee and y'all have the autonomy to try to work out amongst yourself and in your district and move it through the process in those ways. Furthermore, I believe that you will hear that states can't push legislation such as this, that it's a federal issue. And to some extent, Section 230, which this deals with, is federal statute. I would like to also inform y'all that under Section 230, specifically paragraph 3, subsection E, it is an exemption for state-based legislation. It is written in the federal statute that states can pass and hold laws so long as it comports with the general protections of lewd, lascivious, pornographic in nature. Y'all know all of the synonyms that, and you've heard it before, I know. So I just wanted to send that point home. You will also hear probably that this is unconstitutional. And truly for that to be correct, it would have to be heard and struck down by the Supreme Court to be unconstitutional, and we haven't gotten there yet. To claim that it's premature and it's speculative. And lastly, you will hear that this is a not allowing a free market to act the way that free markets should. And to that, I would submit to you that what we see with big tech is not the product of a healthy free market. Big tech enjoys liability protections through Section 230, and in that way, they've been able to unilaterally control free speech on these public platforms. So this law, this bill would it would correct the corruption in the market for Tennessee and for your constituents. We're not saying that any of these companies don't have the right to free speech. They can say what they want. They can do what they want. They can put the tags on any of the posts that, tell you that it might be misinformation, again, or any synonym you might think or any example you may think of. But as my colleague James likes to say, free speech is speaking for yourself, not suppressing others. We don't have a free speech right to gag our neighbors because we don't like what they're saying. So yes, I believe those are all the points I wanted to make. Thank you again, y'all. And yeah, if you have any questions, please let me know.
Thank you, Ms. Fillmore, for your testimony today. Members, Representative Thompson, you are recognized.
Thank you, Mr. Speaker. So you said that because these three corporations are private corporations, is that correct?
Yes, sir.
Okay, but because they control the vast majority of social media, they aren't under the same rules as other corporations. Is that what you meant?
So, are we talking about through a publishing standpoint, or? So
I'm talking about as private corporations.
Yeah, if you'll allow me. Thank you for the question. It's a good question. So what we have is a situation where you have three corporations, private corporations, that control 97% of social media traffic, which in and of itself isn't necessarily a problem, except that they're doing so to take away our unalienable free speech rights. If we're talking about rules by which they compete with each other, if someone can develop a better platform that people like, all the more power to them. And if they gain a lot of market share for that, fantastic. If they have a more user-friendly interface and they utilize that to gain more market share, that's fantastic. But in this case, they're going outside the purview of competing against each other and taking that power, working with each other to go outside the realm of providing a good platform and instead abusing that power to take away our free speech rights. So if I can give you an analogy, I can form a company with 4 of my buddies, and my company can go about robbing our neighbors' homes. The fact that we're a company doesn't immunize us from the fact that we are depriving people of their unalienable property rights. So it wouldn't be lawful for us to do that, and it would be proper for government to prevent us from taking away our neighbors' property rights. Same applies for free speech rights.
Representative Thompson, you're recognized.
Thank you. So, I mean, I'm just wondering. It seems like we're trying to tell. Your request is in this bill is to tell a private corporation what to do, which I think most, the general philosophy in the state government is to stay out of private business. But I understand too. You're saying that they have a near monopoly. The three corporations have an oligopoly on social media, but. What's to prevent another corporation or other social media to rise up to compete with them I guess, not have the abuse that you say they have?
Yeah.
Mr. Taylor or Ms. Fillmore?
Mr. Chairman, Representative Thompson, thank you for the question. It's a great question, and it really gets to the heart of the issue. It's not so much a complaint that the people in Tennessee and around the country have about a few corporations that have risen to dominate this market. It's the fact that they are abusing their power to take away our unalienable free speech rights. So this bill, by focusing not on the fact that it's a few corporations that some would say need to be broken up, but instead getting right to the heart of saying you cannot discriminate, censor, or block based upon political or viewpoint discrimination. So that would apply to others as well. And your point's a very good one. If we had 15 companies doing the same thing, it's harder to have a good outcome than if there are 3, in the sense that we can identify what the problem is. I mean, ideally, we have enough social media platforms where people have choice, but they don't today, and it doesn't look like it's going to happen. And our free speech rights, some people say, well, we should wait, the market will come up with an answer. Well, our free speech rights aren't subject to corporate capture, nor it doesn't make us feel any better if our free speech is suppressed today that it might not be suppressed next year or the year after.
Representative Thompson, and I will remind you, Representative, let's not have too much of an ideological debate here. I mean, the sponsor is still going to run his bill, so some of these, if it's on the merits of the bill, you might want to save it for Chairman Powers. I mean, this could go on a long time if we continue down this road.
I'll just hold mine till later.
Okay.
Thank you.
Committee, do we have any other questions for the folks before us? If not, Mr. Taylor, Ms. Fillmore, thank you for coming to testify today. Members,
you,
we
Mr.
are back
Chairman.
in session. Next, Chairman
may I?
Powers, did you have someone else you want to testify?
No, I've had a comment,
Okay.
and then I'm going to
Chairman Powers, you're recognized.
Okay, thank you. I just want to mention, and it came up during the testimony there, this is a dissenting opinion from Justice Thomas regarding a recent lawsuit. And he said there's clear historical precedent for regulating transportation and communication networks in a similar manner as traditional common carriers. He also went on to say the analogy to common carriers is even clearer for digital platforms that have a dominant market share. Similar to utilities, today's dominant digital platforms derive much of their value from network size. The internet, of course, is a network, but these digital platforms are networks within that network. And the last thing he said was regarding common carriers. He said, it stands to reason that if Congress may demand that a telephone company operate as a common carrier, it can ask the same thing of a digital platform. That is especially true because the space constraints on a digital platform are practically non-existent, unlike a cable company. So a regulation restricting a digital platform's right to exclude might not appreciably impede the platform from speaking. So that was his recommendation in his dissenting opinion, to treat them as common carriers. And with that, I appreciate and I would like to request to roll the bill for 2 weeks.
Okay, Chairman Powers, we actually do have someone else that did want to testify.
I'm sorry.
I think perhaps in opposition to the bill. So
Sure.
we're going back out of session. If Carl Sasbo is here, Carl, you are recognized. Just turn your microphone on, state your name for the record.
Sir. Okay. I'll presume that's on. Yes, thumbs up. Cool. Thank you. Thank you, Mr. Chairman, members of the committee. My name is Carl Szabo. I'm Vice President and General Counsel of NetChoice. I'm also an adjunct professor at George Mason Antonin Scalia Law School. NetChoice sits on the board of ALEC, and I am co-chair of the Communications and Technology Task Force at ALEC. And like many conservatives, do I get frustrated with what I see on social media? Heck yeah, it frustrates me. But I also believe in limited government, free markets, and free enterprise. I believe that private businesses are free to decide what's best for their users and their customers. I agree with decisions like Hobby Lobby, Masterpiece Cakes, and Citizens United, which are predicated on the notion that private businesses can decide what's best for their users and their customers. And I get worried when I see what is the equivalent of government-compelled speech. And yes, I could talk about the Declaration of Independence. I could talk about the Articles of Confederation. But there is a document that supersedes them all. It's called the Constitution. And in the Bill of Rights, we have the First Amendment. And what is it designed to do? It's designed to protect us against government-compelled speech. And that's what we're talking about here today. That's what the decisions in Florida and Texas both centered on. They didn't talk about Section 230. They didn't talk about supremacy clause. They didn't talk about the dormant commerce clause. They could have. Instead, they were centered on the First Amendment. So I have an issue with this legislation. As much as I might love to tell private businesses to do exactly what I want, as much as I would love to have a Chick-fil-A sandwich on Sunday and have the government force them to stay open, I don't think that's the role of government. So from a policy perspective, we're looking at essentially government intrusion. But what does this also mean? It means that we'll have a lot of lawful but awful content. The First Amendment allows a lot of stuff that we don't want to see in our social media sites. Child grooming, we don't want to see. It's constitutionally allowed, but we don't want it. Nazi propaganda, that's political speech to some. This bill has a whole exception about something called a journalistic enterprise. It's written so broadly that Kim Kardashian's content would be considered a journalistic enterprise and a business could not deny or remove her objectionable content. But also, Al Jazeera and Russia Today would be journalistic enterprises, and we could not remove their content. Jumping into the legal perspectives. So we heard a lot about monopolies. Everything's controlled by 3 businesses. I presume the suggestion is Facebook, YouTube, and Twitter. But actually, the most popular social media site last year was TikTok. Just this past week, we saw a new social media site launched, and it launched so well that it actually crashed the servers, and that's President Trump's Truth Social. It's being hosted on a network created by conservatives for conservatives called RightForge. That's the market solving problems, not government solving problems. Let's assume even if they were considered to be a monopoly. Courts have already considered this and dismissed it. PragerU versus YouTube held, despite YouTube's ubiquity and its role as a public-facing forum, it remains a private platform and not subject to judicial scrutiny under the First Amendment. Let's look at the Supreme Court in a case called Miami Herald v. Tornillo, where the government was trying to force a newspaper to carry content it didn't want to carry. Miami Herald was basically the only news source at the time for that area. The Supreme Court said, even though they're essentially a monopoly, they still get First Amendment protections. This is centered around the idea of common carrier. Common carrier, I will run out of time if I go through all the reasons why government can't impose common carrier status. But let's jump to the conclusion. Let's imagine I wave a magic wand and somehow my members were common carriers. They can't be because they don't hold themselves out to be open to everybody. But even if they were, common carriers are entitled to First Amendment protections, as we saw in a case against Pacific Gas and Electric, where the Supreme Court said PG&E was entitled to First Amendment protections from state-compelled speech. We've looked at this a lot. We've testified on these bills across the country. I get it. I understand the frustration. But we can't do an end run around the First Amendment, and we don't want the government becoming the arbiter of what becomes allowed or disallowed on a private business's site. At the end of the day, the market is solving the problem. This bill is not a good step from a policy perspective. It is not legal from a constitutional perspective. And I know I'll probably be back here in 2 weeks, and I thank the sponsor for the upcoming amendments. But as of right now, we're probably not going to support and highly unlikely to support HB 2369.
Thank you, Mr. Szabo, for your testimony. Members of the committee, do we have any questions for Mr. Szabo? If not, thank you so much for coming to talk to us today. Members, we are back in session.
Sir?
Chairman Powell, will you restate what you said a minute ago about rolling your bill for me?
Okay. Can I make one other statement?
Absolutely. You're recognized.
Okay. By the way, this has nothing to do with government-compelled speech. We're not compelling or limiting the speech of any business. That's not what we're trying to do. All we're trying to do is to prevent discriminatory political speech or viewpoints. That's all we're trying to do. We're not trying to compel or eliminate any speech of any company. So with that, I'd like to request to roll the bill 2 weeks, and we got a couple of amendments that we're working on.
Without objection, House Bill 2369 is rolled 2 weeks.
Thank you, Mr. Chairman. Thank you, committee.
Yes, thank you. Next up is item number 6. That's House Bill 1698 by Representative Jernigan. We have a motion. We have a second. Representative Jernigan, you are recognized on your bill.
Thank you, Chairman, for your patience. I think you've been in a chair all day. You realize some of the challenges, I guess, that can come up. Chairman, members, this past year in my district, we had some quite a bit of residential blasting, and the neighbors came to me and talked to me about what can be done. And last year, I worked with stakeholders in the blasting industry to help address my community issues and concerns. And we came up with House Bill 1698, which modernizes and updates the blasting standard by eliminating outdated blast vibration compliance options, restructuring and clarifying blast notification requirements, and providing administrative support for market and industry changes. This bill will lower vibrations, increase communications with the public, and clean up and remove standards that have been on the books since 1975. I'm very grateful for working with the road builders this past year on this bill, and I think we've come up with a really nice piece of legislation. Chairman, this bill has 8 sections. It's 11 pages. I'm happy to give a brief description of each section of the 8 sections, or I can go straight to answering members' questions in regard to each question. I'll leave it to the committee and the chairman on what you want me to do.
Members, did we have any questions for Representative Jernigan? Chairman Zachary, you recognized.
Thank you, Mr. Chairman. Representative, I support your bill. My comments have nothing to do with your bill. I've spent all day in this chair, and with all sincerity, it provides a true admiration and appreciation for you and the model that you are for those who are wheelchair bound to do what you do in such a public setting in the chair that you're in. And Darren, I mean this with all sincerity. I admire you greatly. My respect for you has done nothing but grow today. And when 4:15, I'll be able to put this chair up and get out of this chair. And I know that's not the case for some. And so I have truly, man, my admiration and respect for you. And again, with all sincerity, and especially doing what you're doing, what a hero you are to those, probably like that gentleman in the back of the room. So, man, thank you.
Representative Jernigan, you recognized.
You're very kind to say so. I've been in a chair for 31 years now. I've been blessed over the time with support from family and friends. It does take a village to help someone, especially with a disability. Day-to-day operations behind the scenes is I get up earlier than everyone else, and I go to bed earlier than everyone else. And life with a disability, when you're separated from the physical world and you learn, your activities of daily living become, because I'm a very dependent person. I'm 100% dependent. If someone did not help me, assist me in the morning and at night, I'd be in bed all day long. But because I do have the assistance, I'm able to get up. I've worked most of my life. I have an education that I'm blessed to have, and I'm able to get out there and pay taxes and contribute to society. It's laws like the ADA and the Rehab Act of '73 and IDEA and the Fair Housing Act and the Air Carriers Act and the Assistive Technology Act and the ADA. All these meant to incorporate people into society with disabilities so they can be productive. And every day that I'm down here and able to put forth legislation to help the disability community, because I won't be here forever, so I try to do what I can now. And when you all are able to get into a chair and just get a brief window of what people with disabilities face, that they struggle with every day, I'm glad that you're able to do that. And next year we'll have 5 or 6 more different legislators to do it, and just to get an idea. And so I'm grateful that you participated. I'm thankful for your comments. I take them as genuine, and I'm appreciative of all of you and how you treat me as an equal, how you sit down, look me in the eye, and invite me to stuff, and take me seriously with my legislation. And I feel nothing but as an equal in this body. So thank you for your comments. Thank you, Chairman. And
Thank you, Representative Jernigan.
yeah,
And if you will stick around,
Sure, yeah.
And I'll take a moment of personal privilege. Alex Johnson, the young man who inspired us to get in a wheelchair today, has showed up, and he's in the back of the room. If you guys make him feel welcome.
All right.
And so back on your bill, Representative Jernigan, I won't have you go through it. I'm sure it has been vetted and people have been by to talk with me about it. I do want for the record to state that the Colonial Pipeline did visit with me, and they are supportive of your bill, but they do want, as it moves to full committee, to take a look with you and the road builders and make sure that it's not going to affect them in any way. It's not going to hold the bill up today, but I just want to state that for the record. Yeah.
Thank you, sir. Yeah, my bill is now at the will of the committee, so what y'all wish is fine with me.
Members, do we have any questions on the bill for Representative Jernigan? If not, members, we are voting to send House Bill 1698 to full commerce. All in favor say aye. Aye. All opposed say no. The ayes have it, and that bill is on its way to full commerce, Representative Jernigan.
Chairman, members, thank you.
Item number 7, House Bill 2618, has been rolled 2 weeks. Item number 9, House Bill 2103 by Representative Alexander. We have a motion. We have a second. Representative Alexander, you are recognized.
Thank you, Chairman. Thank you, Committee. The bill I bring before you today comes from the Tennessee Funeral Directors Association, a membership that my husband and I have been very proud to be a part of. This is a bill that's basically a funeral director's legislative cleanup in 3 parts. First part being continuing education for funeral directors or embalmers. Currently, in Tennessee, licensed funeral director and embalmers are required to complete 10 hours of continuing education every 2 years for license renewal. 5 of the 10 required hours must be live, in-person hours, or virtually through an interactive computer program. The bill clarifies the requirements for a virtual continuing education program to qualify as an in-person hours and follows up on a 2017 legislation that was passed and sponsored by Representative Hicks and Senator Crow that did the same thing. The second part of the bill is unlicensed funeral assistant or bad actors, which we have had in this state, prohibits a person who has voluntarily surrendered his or her funeral director or embalmer's license to be considered as an unlicensed funeral assistant. There is a specific bad actor in Tennessee, which the Department of Commerce and Insurance has asked the association to help try and limit criminal activity with this bill. The third part is for pre-need sales agent. In the scope of offering pre-need funerals to the public, a pre-need sales agent and a licensed funeral director are essentially the same. Licensed funeral directors offering pre-need funerals to the public must pay for both a funeral director's license renewal and a pre-need agent registration. This bill would eliminate the need for the licensed funeral directors to pay twice for essentially the same license and registration based on a 2021 bill, which created some confusion as to who had to pay the fee. And that is basically my bill.
Thank you, sponsor, for that explanation. Committee members, do we have any questions for the sponsor? Seeing none, we are voting to send House Bill 2103 to full commerce. All in favor say aye.
Aye.
All opposed say no. Ayes have it. Representative Alexander, your bill is on its way to full commerce.
Thank you, Committee.
Next up is item number 10. That's House Bill 1958 by Representative Alexander.
Thank you, Chairman.
Do we have a motion? We have a motion. We have a second. Representative Alexander, you're recognized.
Thank you. This bill I bring for you is from the Tennessee Realtors, And this legislation is being brought by them and seeks to remove the requirement that synchronous education courses for real estate licensees be certified by Arillo. Arillo certification comes at a large expense to the providers on top of the already required approval of the courses by the Tennessee Real Estate Commission. This law change would treat synchronous courses the same as in-person courses, and there should be no distinction since the instructor can see the students and monitor the students' activity. This bill will allow education providers who have been utilizing technology to teach synchronous education courses the option to keep using those learning platforms without the costly Arillo certification requirement and keeping the courses affordable for real estate licensees. And that is my bill.
Thank you, sponsor, for that explanation. Members, do we have any question for the sponsor? If not, members, we're voting on House Bill 1958 to send it to full commerce. All in favor say aye. Aye. All opposed say no. Ayes have it. The bill passes.
Thank you, committee. Thank you, Chair.
Members, that concludes our business for today. So I hope that you'll stick around. We're going to hear from Alex Johnson. And then we're going to, if you're in a wheelchair, we're going to meet out there in a moment and have a picture. But that concludes our business today. This meeting is adjourned.